Alrighty, folks, looks like we are live. I'm George with Solo. I'm the founder of Solo. We help people resolve debt. A lot of people come to us to use Solo Suit to respond to the lawsuit, and then Solo Settle to get their case fully settled. And we are here with my friend John Skiba. John, can you go ahead and tell us a little bit about yourself?
Yeah, George, it's good to be with you again. I'm an attorney in the state of Arizona. I help people who are being sued by debt collectors. And, I know that's how our paths really crossed as far as the work that you do there as Solo. I do it here with my clients in Arizona and helping them who have been sued by debt collectors. I also do a lot of bankruptcy and just kind of general consumer debt issues. But I'm happy to be here.
Fantastic. Love it. Glad to have you on the debt hotline today. So, folks, this is the debt hotline. We're going to be answering any of your questions that you have. There's a lot of people watching live, so if you have any questions, just go ahead and put those into the chat now. We'll be getting to some of those questions. We also prioritize responding to people who call in to our hotline. So there's a number of people who have called in to our hotline and left us an audio recording, so we'll be getting to those questions. You can also write in as well. We'll get into a couple of the questions for those as well. John, let's go ahead and start off with this doozy here. And the overall topic is how to resolve and work with LVNV Funding. Here at Solo, we have a good relationship with LVNV. We also have a great relationship with consumers. For us, we're trying to really be a trusted mediator for both sides in these debt disputes and help people get things resolved amicably. So we have Lynn in Arizona, which is your state, John. So Lynn here, she says, presently in a lawsuit with LVNV, answered the complaint using Solo Suit. Excellent, great. We think about that as the first step, oftentimes towards settlement, and oftentimes it's like the first time the collector has heard from somebody on the case. And then they filed a motion to dismiss with prejudice. Okay, so she's moving to get the case dismissed rather than settle. The plaintiff, LVNV, failed to file the disclosure statement within 45 days, pending the judge's ruling. If the judge rules against us, LVNV sent the disclosure statement and documents not signed by the attorney, multiple exhibits of the same page, blank pages, redacted spreadsheets that literally say redacted, blacked out statements, no proof of previous attempts to collect the debt. How do I fight this? Our theory is to pay before going to court. The debt is less than $800, but LVNV filed 1 week before the statute of limitations expired. Pretty intense move, right? Filing for the lawsuit for just $800.
Yeah.
And, right, as I'm sure you see, filing just a week before the expiration date isn't uncommon.
Sure.
Right? Buzzer beaters do happen with some regularity. So if it comes right to the nuts and bolts, can we pay Resurgence, which is another name for LVNV? Can we pay Resurgence, and how do we prove to the court to dismiss and remove this case from my credit report?
All right. Lots to unpack there. So I should say this, if you're planning on filing a motion to dismiss the case because they didn't provide the disclosure statement or issues like it wasn't signed, or maybe there's some duplicates in the documents, not likely that that's going to be successful. The reason is that that's a disclosure, discovery type issue, and the courts will usually allow parties to remedy those types of issues before they even impose any sanctions. And really the sanction is not dismissal. It's really more of they may limit what they can use in the trial itself, like in a motion for summary judgment if it went to trial. So I don't think that a motion to dismiss would be successful. I do think it's something, this is a perfect example of a case that probably should just be settled. $800 case, they'll probably take considerably less. They'll probably take anywhere from a third to a half of that to be able to get this resolved. The important thing is once they agree to dismiss the case, if you have filed an answer, which it sounds like you have, you're going to have to agree to it. So it's going to be a stipulation to dismiss. You want to make sure that they sign a release, that there's some acknowledgement that the debt is dealt with, that you don't owe anything any further. Now, the credit reporting issue can be a little bit more tricky to navigate. It really depends on excuse me, LVNV and what their policy is, or sometimes the policies of whoever they bought the debt from. Sometimes they will agree to delete it completely. Other times they give, and I run into this all the time in my practice here in Arizona, where they'll give us some pushback and they'll say, look, there's this federal law called the Fair Credit Reporting Act. It states that we have to report accurately. So what they'll do, instead of deleting it, they'll show that it's been, it'll say settled for less than the amount owed, which granted is not as good as just a deletion usually as far as your credit score goes. I have a little bit of sympathies, because it's true. The Fair Credit Reporting Act does say they have to report accurately, but it also doesn't require them to report at all. Creditors voluntarily report this information to the big three credit reporting agencies. So I always say, look, ask for it, push for it. But if that's the difference between settling and not, I would just get it settled, get it, resolved and move on, and your score will still improve.
Right. I think fantastic tips. Lynn, if you are on the live stream now, we'd love to hear more about your financial position, right? Like how much are you making a month? How'd you get into this debt? Those are some questions I think that we'd have. For an $800 lawsuit, it very well might just be easier for you just to pay off some of it, pay off all of it. Depends on how fast you want it to go away. Right, maybe you can get a payment for $400, maybe you can get a payment for $600. Probably definitely want to do all that you can to get this done in a lump sum. Probably don't want to get onto a payment plan for this size of a debt, but the collector probably accept a payment plan as well if you want to. All right, and what we see as a strategy that oftentimes works well for people, right, is using our answer document to file the initial response. Once you file the answer, you aren't done. You didn't win because you filed an answer. It's not just finished. We usually think about that as giving you leverage to then settle with the collector if you owe the debt, right? If you don't owe the debt, then you can go a different path and communicate with the collector that you do not owe the debt. This is like an identity theft situation or something like that. All right, great. So we have it looks like Lynn is on. So yeah, Lynn, can Solo help form the stipulation? So she's asking, can we do the stipulated dismissal or the stipulated judgment for her? No, the collector, well, we do have a pretty powerful AI tool that you can use, which is just our Solo AI. You can chat with it anywhere on the website. Usually the collector will be the one who will create a stipulation, like a stipulated dismissal for you. It's pretty standard for them. They'll have that ready to go. Once you pay the debt, they'll just create the stipulated judgment, or even before. Once you agree to pay the debt, they'll create the stipulated agreement, and then you'll sign it, then they'll get it filed in court. Is that right, John?
Yeah. I mean, usually the creditor takes the lead on that, and then you'll have a chance to review it, make sure the terms are in there that you want, and then you sign off on it, and they'll even file it. So I would let them take the lead on it. They have those templates; they're good to go, and as long as it says what you agree to, I think you're fine to do that.
Right. Lynn, how did you get into this position here with this debt? Go ahead and let us know in the chat. Just to help you out more, we'd love to know how you got into this spot. She's asking, who do I pay? And so she asked, pay who and reach out to LVNV with the offer. Good question, right? So there's usually a law firm. When you're being sued, there's usually at least two parties. There's the law firm, and then there's the plaintiff. The plaintiff could be a debt buyer like LVNV. It could be the creditor like Discover. And then the law firm could either be like an internal lawyer like Discover's in-house attorney. Usually more commonly, it's going to be a law firm. And you will want to contact the law firm and make the offer to the law firm, and they will work with you. They're representing LVNV in this situation. And she's saying that it is her husband's old debt. So Lynn got into this debt with through a spouse, which happens. Glad you're helping this get wrapped up, Lynn. Taking care of the husband, maybe playing a little bit of a sugar mama role here, and getting it taken care of. Okay, yep. So the law, Lynn said that her law firm is Gerstel. Lynn, Solo works a lot with Gerstel. A lot of people bring Gerstel cases to us. You can definitely get that wrapped up through Solo Settle if you want a quick and easy resolution. We help people settle with them regularly. Great. So jumping into, Liz just pointed out that her husband does work hard. So that's good. It's good to know. I'm glad to hear it. Very glad to hear it. Great. Jumping into the next question. We have an audio question I'm going to play.
Hello, I have an original debt of approximately $23,000 with Citibank. It was sold to LVNV, and I've made it to 2 out of the 3 case conferences. They didn't show up to the 2. I'm not sure if they showed up to the 3rd one or not. But my main question is there a chance that LVNV bought this debt and that the case doesn't have any standing, because it's right on the edge of the expiration date of 4 years as far as potentially having the debt eliminated or not? That's my main question. I'll make sure that I'm on the call with you coming up in a day or two here at 4 o'clock Pacific time. Thank you.
Okay, great. So it sounds like he's in a lawsuit with LVNV. John, what's your take on this one?
Yeah, the one thing initially I tell people, because I run into this similar type question all the time, is there's sometimes some confusion as far as the statute of limitations. He mentioned in there that sounds like he's been to a few status conferences or maybe a pretrial conference, and it's something where that he's thinking maybe the statute of limitations is almost expired. The statute of limitations deals with the amount of time from when the account goes into default until the creditor, LVNV here, files the lawsuit. Once the lawsuit is filed, assuming it's within that statute of limitations, he was saying it was 4 years in his state. If they're within the 4 years when the lawsuit's filed, it's been met. It doesn't matter if the lawsuit takes 20 years to finish it up. It's not going to take that long. If it did take a long time, doesn't matter. It's as of the filing date. So the time that elapses after the lawsuit's filed is not part of the statute of limitations. That's just the case pending before the court, trying to make a decision as far as if there's liability there or not. So that's the one thing I'd look at. Other thing that I would look at, if you're going to hearings, and this is just across the board, if you show up to a hearing and the other side is not there, I often ask the courts to dismiss. And I can tell you, I run into this all the time where the courts are like, well, maybe we'll just continue it down. And I always say, Judge, respectfully, if my client didn't show up to some of these hearings, judgment would probably just be entered against them. So I always say you can do that respectfully and push back and say, they're not here. Or, hey, I've showed up twice now and they're not here. This should be at a minimum dismissed. And if it is dismissed, dismiss it with prejudice so it's not filed again. So it doesn't hurt to ask if the creditor is not showing up, to ask for the court to do that. If you're making the time to be there. Now, he did say he wasn't sure if they showed up at the last one. It makes me worry that maybe he wasn't at the last one. But showing up for all of these things, whether it's filing an answer, whatever it is, that's about 80% of the battle in these things. Just making sure you're there so that a default's not entered. Because if you file an answer, show up, that gives you some leverage to be on a more equal playing field, to reach out to Solo and do some type of settlement or something like that to get it resolved. So being engaged is really important on these.
Fantastic. I think that's all totally on point. I agree wholeheartedly. Got another audio clip coming up here. This one is from Sherlonda.
Hi, my name is Sherlonda Willis, case number 49D04-1905-CT-019134. Question 1. What is the reason for a transfer of my case, especially when I've been paying monthly payments faithfully to the plaintiff's lawyer? Question number 2. Can a law firm transfer my case me being the defendant to a different law firm without my consent or knowledge? Question number 3, why did the plaintiff's lawyer falsely accuse my daughter and I, the defendants, of non-payment, which resulted in employment searches and the default of judgment? My daughter operated my vehicle at the age of 17, no insurance, which resulted in an accident in 2017. The original lawsuit amount was $2,000 plus. Then it increased to $17,000 plus, and it went to $23,000 plus, and now it's settled back at $17,000 plus. Why this fluctuation? I haven't contacted the new law firm. I can't afford a lawyer. I've been researching for assistance and help to no avail. The court is June 24th, 2025, which is 3 hours away. What are my legal options? Thank you.
One, I gotta say, it sounds brutal, Sherlinda, that the court is 3 hours away. That's a real thing, and one of the big things Solo does is helps people. Our software makes it easy for you to file the document within the court, so you don't have to drive down there and hand deliver it. We also, hopefully, with Solo Settle, can get you a settlement so that you don't need to drive down to the court. So all that said, John, what do you think?
Well, a couple things to address the questions. I mean, the first one, she brought up the issue of whether, they transferred, the plaintiff transferred attorneys without her consent. The court's going to allow them to do that. If it's something where a plaintiff decides they don't want to use the same attorney, or if there's, for some reason, they fire their attorney, they're going to have to file usually some type of substitution of attorney with the court to put everybody on notice so that you have the correct contact information with the new lawyer. But the court's not going to allow the defendant to really object to that, really, because it's right from the court's perspective, that won't likely impact the defendant. At least, that's a contractual relationship between the plaintiff and their attorney. Just like if a defendant had an attorney and decided they wanted to change out who was representing them, the plaintiff wouldn't be able to stop that either. Now, as far as the amount, so this brings up kind of a bigger point that I think is super important. She mentioned that there's payments that are being made that haven't been accounted for. It's extremely important if you're making payments to a creditor that you keep records of that. If you're calling things in over the phone, you need to ask them to email you a receipt. You need to keep your own records, your own bank records, because this happens frequently. Now, a lot of debt collection firms, they're highly regulated. If you've ever gone to a true debt collection firm, you have to be buzzed in. It feels like it's on lockdown. They're highly regulated as far as because they're dealing with all this money, they're dealing with their clients' money. All attorneys are regulated, in that aspect. But it's still important to keep records because if they're not accounting for that correctly, you need to be able to raise that, and you need to communicate that to the new attorney. And that's true of settlement, anything. I always say, don't pay money until you have some type of acknowledgement in writing that you've got a deal in place. I don't care if it's an email, a letter, a formal settlement agreement, whatever it is, you need something you can point to and say, this is why I'm making that payment. And then I think you're going to be better ahead. And then lastly, if you're not able to get this settled, the travel time to the court, you may want to request to be able to appear via Zoom. That's one of the byproducts of the whole COVID era is most courts allow that now. When I defend debt collection lawsuits, and that was always one of the things I objected to was the creditor coming in via Zoom, and at least in Arizona, that's not an objection that's well taken anymore because they allow people to, particularly doing that. That's a substantial distance. I complain when it's 30 minutes. 3 hours is a lot. And so I think the courts may allow you to do that. But again, that may be a reason to get it resolved. Most civil cases are settled. There was some statistics by the State Bar in Arizona. Civil cases, 98% settle before they go to trial. I think that's not a bad option with any case, really, for you to control the terms and to come to some resolution to it.
Great. Yeah, we have a question. I think just wrapping up that one, John. Yeah, that is all great questions from Shalanda. I'd weigh in on one point about the transfer, right? Sometimes people are confused about the debts being transferred. Unfortunately, that is a common reality, and it is totally legal for debts to transfer from one party to the other. The documentation has to be correct, has to be properly documented. The assignment has to be legitimate. It is something that occurs with regularity. It also occurs even before the debt is charged off, right? Mortgages get traded around all the time without the borrower's consent, really. I mean, the borrower does consent, but it's just in a contract. And then once you are on the mortgage, you don't really have much say. The bank can just sell the mortgage to another bank. And all of a sudden you have to make payments at another place. And that can happen with other types of loans as well. Before charge off, after charge off, etc. Oftentimes people are pretty confused about that, but it is a legitimate practice that occurs regularly. We have a question live from the audience. We got a question here from Hussein. I was under the impression that solo suit was about helping people protect their rights, not sell debts. Does solo suit help to truly defend the defendant's rights? Hussein, glad you brought this question up. You know, we're all about transparency at Solo, so happy to address that. For us, what Solo is Solo is a trusted mediator between consumers and collectors. Right? So when you work with Solo, you use our software to pretty much do whatever you want on our software, right? So you can use our software however you want. You can do anything you want with it. If you want to angle kind of more aggressively, you can. The software is designed to help people in what the most common use case is, which is responding to the lawsuit and then getting the case settled with the collector. That's what most people want to do. If somebody's coming to us and they legitimately owe some of the debt that they're being sued for, settlement's probably just going to be the best option for them. And that's because, you know, you can respond to the case, you can try to get it dismissed, but even if you get the case dismissed, that isn't winning the case. The collector can still try to collect on the debt outside of court. You might still owe the debt can still be reported on the credit bureau, even if it's dismissed. Unless you take the case all the way before the judge and then you prove to the judge and the judge gives an order saying that you do not owe this debt, you can still be on the hook. So, and that said, you know, lots of people use Solo with regularity to communicate to the collector that they don't owe a debt that they're being sued for and getting it wrapped up that way. So that's addressing that question. So glad you brought it up. And in some places, so like with Solo, for example, like we don't have like a pipeline built around suing the collector for an FDCPA claim. You can consult with other attorneys about doing something like that and look into that in another spot. All right. Let's see. We have another question here let's see. We have another live question from Lisa. How do you know if it is best to file for bankruptcy rather than working to settle?
Well, it's a good question. And I think it's very individual to each person. You know, a lot of people are surprised there's no specific dollar amount that you have to file debt. I've said before that I've had people come in who owe $100,000 in credit card debt, but their income was such that they could probably settle this and get it resolved without bankruptcy. I have personally filed a bankruptcy for someone who owed $9,000, which is relatively low, but their income was such that there was zero chance it was ever going to be paid, and there were lawsuits and everything else. So really, I think what I tell people to look at is if you've been battling the same creditors for years. Basically, if you're paying monthly minimums, the balances haven't been going down, and you don't anticipate your financial situation changing. If you're doing balance transfers, if you're using one card to pay the other card, basically if things are starting to spiral. A lot of times what pushes people into bankruptcy is they wait long enough where they're getting lawsuits, they're getting garnishments, they're getting those types of things, bank levies, where it forces their hand. But if it's something where, I mean, my rule of thumb, if you don't feel like you can pay these debts off in like a 3-year, window, like doing a Dave Ramsey snowball kind of thing, or if you've been just, if it's been 10 years and you've got the same card, it's at the same balance, and you're just continue to, I would say that's when it's time to think about it. If you do it early on before lawsuits come, then, maybe you can avoid the bankruptcy altogether, but it's usually the lawsuits, the wage garnishments. That's what really, then a lot of times the decision has to be made just to stop that. So those are the kinds of factors I look at.
Yeah, so Lisa provides a little bit more context here. My issue, Lisa says, is that I have just suffered my 3rd layoff in January. It only lasted 2.5 months. For the 3rd time, my savings has been eaten up by significant medical expenses to fight for my health. How's that change things for you at all?
Yeah, I mean, medical issues are, I've had clients come in and they literally have hundreds of thousands of dollars of medical debt from an illness that they're dealing with, hospital stay, things like that. Then that's a little different than as far as, if there's just a kind of a nagging credit card that's causing you problems. Medical expense is treated differently. That's one thing to be aware of. In my experience, they're willing to negotiate a little bit more. They typically do not report it on your credit report until it's been at least a year delinquent. There was a Consumer Financial Protection Bureau ruling that was going to go into effect that would stop all medical collections from showing up on your credit report. It did not. When the Trump administration came in, the kibosh got put on that. And so they will do it, but it does have to be a full year past due. So there is a little more flexibility there. The issue that, Lisa, you're dealing with here, it sounds like with job loss, no reserves, it's putting you in that situation where you're unable to pay. I think it's worth going and consulting with the bankruptcy attorney. There are other factors that go into it. Sometimes there are assets that you have that you're at risk of losing. Sometimes there's certain transactions. If you've had a loan you've been paying back to a family member that could impact a bankruptcy decision. It's worth talking to. Most bankruptcy attorneys I know around the country do a free consult. It's worth at least talking to him and seeing if some of those other things will impact the overall decision.
And Lisa follows up. The only reason I still have these debts is because of my 3 consecutive layoffs starting in 2020 to this January. She says, I don't have medical debt. I have used my savings to pay for medical needs. Because of my layoffs, I had to choose healthcare over paying the cards. Everything I paid down has been harmed now. Everything I paid down. Okay, so she's working on paying them down. John, this is a situation that we see with some regularity, which is medical debt oftentimes doesn't look like medical debt at the end of the day, right? People have medical issues. They pay for the medical issues. They pay for the medical procedures. But then to cover other expenses, they get into credit card debt. Right? Or they pay the medical debt with a credit card. Right? They'll pay the bill for the medical procedure with a credit card. Oftentimes, what I see that I think is most a pretty surprising instrument in this space is when somebody's going through a procedure and then someone goes to their hospital room, offers them a credit card specifically for that procedure to pay for the expense, right? Which is pretty, that's definitely something you want to avoid if at all possible. Because oftentimes those rates can be, something that you don't want to enter into, right? They can be pretty concerning. All right. And then, Lisa, my take on the bankruptcy is I think about it in just following up on John's take, really. Think about it in 2 ways. One is debt to income ratio. That's what banks look at to determine if they want to loan you more money. They'll look at that. They look to see a debt to income ratio below 36%. That means less than 36% of your monthly income is going to pay off debts that you have. So that means like your mortgage and your auto loan are less than 36% of your monthly income. If it's higher than that, that's not the end of the world. But if it gets into the place like 60 to 100% to 200% of your monthly income is going to debt, then bankruptcy is very likely needed in that situation. Also, the other place to look is in your assets, right? So if you have maybe you have a high debt to income ratio, maybe you have to pay 200% of your monthly income on debt every month just to make things work. But then you have $100,000 in a savings account somewhere or in the 401k, then maybe bankruptcy doesn't make sense in that case. Or you have like $100,000 in equity in your house, bankruptcy maybe doesn't make sense in that situation. And you can just draw on your savings to pay down these debts and get out of debt. A little bit more context here from Lisa. Happy to be having a conversation with somebody on here live. I currently have 3 forms of cancer. Very sorry to hear it. My mom and I are being poisoned in our home by leaking pipelines and a collapsed sewer line. The house is technically not habitable and needs to be condemned. Hence, I am in the midst of a compounded, multifaceted problem. I've never known such days.
You know, George, one thing that in situations like this, I think of some people call it like the 4 walls. You know, you need to focus on, if there's limited funds and a lot of other issues going on, focus on the 4 walls of the home. Make sure you have a place to live. Make sure you have food to eat, you know, gas in the car, groceries, that kind of thing, pay for your utilities. If it's to that point and you can't cover anything else, I think that's an indicator for potential bankruptcy filing. Where you could get a lot of relief. If it's something where there's just no possibility to settle debts, because frankly, there's just barely enough to survive right now because of all these other factors are going on. I think that's one way to look at it, is kind of prioritize what you need to be paying. Because kind of to your point, I see it all the time where people, they're paying credit card minimums and literally not buying food, you know, or not paying their house payment or their rent or whatever to pay off the credit cards. You got to prioritize at some point the basics for survival, and then other ways, if settlement's not possible, then maybe bankruptcy option.
Right. Lisa continues. I can no longer, nor would I obtain any more debt. I have no income currently, cannot find another job. Working 100% commission job to try to earn some income. Sorry about the layoff. You know, as far as income goes, right, there's certainly a growing gig economy currently, Lisa. I always say, you know, it's admittedly somewhat self-serving, but I always say, you know, if you want to make income pretty quickly, you can always become a partner of Solo. You just click the affiliate partnership link in the bottom of our website. You can sign up in a few minutes, and then you can start referring people that you know to the site, people who need help financially. And we, you know, can oftentimes give we always do give a referral payout for people that you send our way. So we're happy to help you out in that regard if something like that makes sense. Jumping on to the last question here. We have one more live question. This one is from Hector.
Hi, good evening. My name is Hector Beatriz. The question is the following. I'm being sued for Discovery bank account, credit card. Once I found out I was being sued, I replied to the suit with just basically saying that I do not agree with the amount and that I was the victim of identity theft, which I was. So then after that, we had court on May 17th to go to trial on May 17th. I'm sorry, on April 17th. However, I received a letter saying that the plaintiff had dismissed the matter. Then a week after April 17th, I received a letter in the mail saying that I'm being sued again with the same Discover bank account. So I'm not sure if after the plaintiff dismisses the case, I'm not sure if they can go again and refile a new lawsuit. Just, I guess I would like some advice on how to proceed with this situation. Thank you.
Yeah, they can do it. If the lawsuit gets dismissed without prejudice, which usually if it's just voluntarily dismissed in the beginning, or sometimes it's dismissed because they didn't serve it, assuming that the statute of limitations is not run, they can refile it. And I have seen that in situations where there's an identity theft claim, they'll dismiss it. And then if they evaluate it and determine there's not an identity theft issue, they may refile it. In my experience with most debt collection firms, if you say, hey, there's an identity theft issue, they often have what's called an identity theft affidavit they have you fill out, which gives them some background facts related to why you feel like there was an identity theft type issue. It's also something where I always say it's a good idea to file a police report, just so you can show that you have that as something to substantiate the identity theft. Usually, in my experience, the police don't do anything with it, but it's good to have documentation to show, hey, this is legitimate. I tried to get this squared away. And I have had routinely, if that's filled out, and particularly if it's been substantiated with a police report, they often will dismiss with prejudice and give you a full release on it. So that's something you may want to ask about, is if they have that, and then be able to get that thrown out altogether if you can get that submitted.
Yeah, how important is the police report in this kind of situation, John?
How what?
How important is the police report in this kind of situation?
I mean, it's not that. I mean, it's one of those things that's nice to have, but it's not. But at the same time, if you don't, it's fine to go out and just let them know what the situation is, and then they'll often provide that affidavit you need to fill out. Now, they're going to require a lot of information in there about you and about how the whole thing played out. But it's something where I think, if it's a legitimate ID theft case, you need to submit that, and you need to continue to pound that defense all the way through the lawsuit, so that the court's aware that, you're consistently making it. It's not just a one-off thing. You're legitimately saying, look, this is not mine. I didn't make these charges. And in most states, if you can come in with that defense, you may not be held liable. It's always kind of a tough defense because you're kind of trying to prove a negative, prove that you didn't do something. But it is something, if you have that police report, it's one of those things that can kind of help sometimes push it over the edge to get them to dismiss.
Yeah, that's for sure. Let's see. Okay, just wrapping up here, we got a follow-up from Hussein. Looks like people could hear my baby. That was my baby in the background. Got a little newborn little guy. I think it's awesome to have the baby in the background. Congratulations to you and your missus on the newborn. Thank you, Hussein. Appreciate it very much. Thank you. And then we have a thank you from Lisa. Thank you so very much, very, very much. It is overwhelming. I have fought very hard to protect my credit score. Survival is indeed where I am. Glad that we could help you out, Lisa, with this issue, and we hope, to all of your sincere hope, is that we can help everyone, get back on their feet, get back on the right path financially. Build your credit score, build your wealth, build your prosperity, and that's what we're doing here at the Debt Hotline. John, thanks so much for coming on the show. Thank you, everybody. Until next time.